Good morning and welcome to today's webinar. My name is Jeff Stauffer, Community Relations Director with Elville and Associates. And we have a very popular and important topic today, Understanding Estate and Trust Administration, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. And I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. And if you're coming back to see us again, thank you for being here as well. So you as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout to address them. Your questions really help the presentation and add value. They also help others learn. So please don't be shy in posing your questions at any time. You also received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you didn't receive the presentation yesterday, it is available now in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's webinar, welcome as well. For CPAs, CFPs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So per my attendance records requirements, please email me your board ID. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I'd like to do tomorrow. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this simple survey to offer us your feedback about the presentation. We read every comment and value the information that you share with us. It's also an ideal time to request a consultation with Steve for any planning needs that you may have, and we always want to be a resource for you here at Elville and Associates. So with all that said, we have a lot to cover. I'd like to share with you an overview of our firm and a little bit about Steve before we get started. So you should be able to see my screen here. Elville and Associates, founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We do a lot of things here at Elville and Associates, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and we're coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do offer a lot of education here at Elville and Associates, and we do that in several ways. Through our planning processes with our clients, we do offer over 100 educational webinars and workshops in the communities we serve each year. And we did offer our first in-person workshop live the other day at Miller's Grant in Ellicott City, which was wonderful to do. We really enjoyed it, and we hope to get out there again very soon. And also by way of our accredited client care program, we are one of only 2 firms in Maryland to have an accredited CCP, as we call it, accredited by the Client Care Academy in Boston. And we also work with the ideals of client education, collaboration, and compassion in mind with every client, every time, every day. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve speak before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also named to the Maryland Super Lawyers list for a 7th time in 2022, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center and what we do to make a musical difference in the lives of children each day, I'd be more than happy to share some information about it with you at another time. So just reach out to me and I can talk about it all day with you. So with all that being said, we're going to go ahead and jump into the presentation here. First, I want to start off with just a brief poll to see what your experience has been with the estate and trust administration to date. And I'm going to go ahead and launch that poll. Just choose the option that best suits your situation. And the choices are, I have been the executor of an estate in the past on my own. 2, as an executor, I sought professional guidance throughout. 3, I may be asked to be executor of an estate in the future. 4, I want to keep my planning in order to keep costs down. Or lastly, I'm an advisor here to learn to better serve my clients. So just take maybe 20 or 30 seconds to make the choice that best suits your situation. We appreciate your participation in that to see who we have joining us today. Okay, so it looks like everybody who wants to participate has. And with the votes in, we have 10% saying I've been the executor of an estate in the past on my own. Another 10% saying as an executor, I sought professional guidance throughout. 38% say I may be asked to be executor of an estate in the future. Another 24% say I want to keep my planning in order to keep costs down. And another 19% say I'm an advisor here to learn to better serve my clients. So Steve, we have a varied audience today, and welcome to all.
Thank you, Jeff.
Being here. Steve, I'm going to share the screen.
All righty, I'll take
you
over.
The presenter. Should see that button pop up in just a moment.
I will show my screen and take over. And Jeff, I'm going to minimize my screen here and see if you can see the presentation. And you should be able to see the full presentation. Thank you, Jeff. And good morning, everyone. And I want to say happy Wednesday to you. And I am coming to you from conference room 1 of our Columbia office in Columbia, Maryland, here at Elville and Associates. And it's my privilege to be with you today and to be the principal attorney and lead attorney of Elville and Associates. So thank you for spending your valuable time with us this morning. From my point of view here, I can see that the sun is shining outside. We're having a much needed break in the weather. Jeff is much more in tune with the weather than I am, but I think that's the case today. So I hope you get out. I hope you enjoy. And I also want to thank Jeff, my longtime colleague and friend who makes this possible. And Jeff is a wonderful moderator. If you've heard our presentations before, you know you can ask questions. If you haven't heard before, haven't participated, Jeff is on standby. He will take your questions. We're going to stop at various points of the presentation, and you will have an opportunity to ask questions. Our goal here today is to be a resource to you, to teach, to provide an overview, because the topic of estate and trust administration is very broad. We couldn't possibly cover it in an hour or an hour and a half, and we're not going to try, but we're going to make this what I would call a mini master class. If you can take away some things today, you're going to know a lot more than others about the administration process. And I want you to use the handout as a tool. And Jeff sent out the presentation yesterday. I took the liberty last night to change some of the examples that I routinely show. So those of you who are seeing this for a first or second or third time, you're going to see new examples, and we're going to go through those live examples. And I also want to just say that we are sensitive to the fact that many of you are watching this webinar because you do anticipate being an executor or a trustee. And some of you may have experienced the loss of a loved one, and we send our sincere condolences if that is the case. So we know this is a sensitive topic, it's an important topic, and for some of you it's a real thing right now. So we want to be sensitive to that. And again, I want to be a resource to you from whatever vantage point you are coming from. Okay, so we're going to get started here, and Jeff, I'm going to start the presentation. Again, I want you to know this is a relatively informal presentation where you can always ask Jeff questions. We will attempt to stop intermittently through the discussion, and we're going to go ahead and get started. So thank you for being here. All right, today we're going to talk about what is this mystery of what happens after the death of a loved one, and how do we look at this? For example, I'm going to argue today that administration is really a process, and process should drive everything. Process doesn't always cover everything. There's lots of twists and turns. There are unexpected things that happen. There are surprises that happen. There are legal technical things that have to be resolved. But a process, if we're driven by process, we're going to get 85 to 90% of where we want to go most of the time. And along those lines, I want to show you as we get started that you've been provided with this tool, or these tools, I should say. There's two of them. And I'm going to call these critical date checklists. And if you will reference these throughout the presentation, you'll get a sense of what I mean by process. Many of you who have administered an estate before, for example, a probate estate, if you've dealt with a register of wills in Maryland or another state, you'll notice that many times the register of wills will provide a process for you. They'll provide a roadmap. Well, this critical dates checklist is not exactly the same as that, but in some ways better, because it points out some of the most important points along the way. So there are certain hoops that have to be jumped through, and there are certain deadlines that we really can't miss, and we can't minimize these deadlines. So there are certain tax elections, and there are certain spousal elections, and so forth, and certain dates where administration accounts are due in an estate. Now, of course, in a trust administration, we're talking about a similar but different kind of process. But just know I've provided you with two critical date checklists, one for a probate estate and one for a trust estate. And these are not meant to be comprehensive or all-inclusive, but just know that this is the substance of what we're going to walk through this morning. We want to minimize confusion and provide maximum support. If you're an advisor or a professional on the call here this morning, we want to provide maximum support to our clients. If you are a non-professional advisor and you're a client or a prospective client, or you're a prospective personal representative or trustee, we want to provide support to family members at times of crisis. That's very, very important in administration. That has nothing to do with the legal technical aspects, but that is extremely important. What is the legal step-by-step process that needs to take place? So there are processes, and then within those processes, there are legal steps. So there are legal aspects to certain things that we need to consider. There are practical steps that should be followed. So at some point during this presentation, I'm going to be redundant, and that's on purpose. You're going to see something that might pop up 2 or 3 times because I'm trying to drive home certain points. We want to examine the most significant and problematic legal and tax issues that advisors should be aware of. And I'm going to go as far as to say not just advisors, but the actual trustee or executor should be aware of following the death of someone. And we want to talk about how personal representatives, trustees, financial advisors, CPAs, and attorneys can work together collaboratively to support other professionals and to support our clients. And so let's get right into this now. We want to unravel what happens upon the death of someone. So in estate planning, if I step back for a moment and I say, well, we do a lot of estate planning. Well, what is estate planning? Estate planning is the first step in the process of the actual events that lead up to administration. So hopefully the person who has passed away has an estate plan. And of course, I'm making a lot of assumptions here that the person probably has an estate plan, but we know a lot of people don't. But let's just assume that a person is responsible they have concerns about planning, and let's say they implement an estate plan of some kind, a will or a trust of some kind. And let's pretend now that we've got 3 phases. We have the planning phase, we have what we hope is the maintenance and updating phase of the planning, meaning that's where the plan is maintained, that's where the plan is perfected really over lifetime. And this usually doesn't happen, just to let you know, but that is our goal. And then what we're talking about today is the final phase. What happens upon death? That's the final phase, administration. So this is one of the client's greatest concerns is if I have a revocable living trust, for example, and remember a revocable living trust is nothing more than a substitute for a will. It is a will substitute. Well, one of the most common questions is, what happens upon my death? What happens to my revocable trust? Well, the answer is actually pretty straightforward, and many of you know this answer. It becomes an administrative trust. So if we look at the third bullet point here, if we have a trust, there is an administrative trust. Now, what does that mean? That means our revocable trust has become irrevocable, and it has to be administered. This is the administration period. And as you look at the fourth bullet point here, I would call this the transitionary period or the administrative period. Someone has passed away, and now that trust has to be administered. This could be a relatively simple administration on the death of the first spouse to die in a married couple, and at the death of the second spouse or on the death of a single person, obviously, then what we have is maybe a bigger administration. But that is one of the key questions that many people have. What happens to my trust upon my death? The answer is it becomes irrevocable, it becomes an administrative trust, and it has to be administered. If you can grasp that concept, then we can go back to bullet point number 2, and many of you are somewhat familiar with this. We're either in practice or psychologically familiar. Someone dies and they have a probate estate. So probate is that process. We're going to talk about it this morning. It usually lasts about 9 months, but not always. There are other ways of streamlining an estate, but usually it's about 9 months for a regular estate. But the same concept is true. Someone has passed away and now their estate has to be administered. It's very similar to the trust. The trust becomes irrevocable at death and now it has to be administered. So if you can solidify that concept in your mind, that is what we're talking about today, is one of the greatest concerns of people in estate planning. What happens upon my death? How does everything get administered, whether I have a will or a trust, and even no will? We're going to talk about that and what happens. So that's what I would call the transitionary period. Now, who will be there for the surviving spouse and loved ones? Okay. Well, this is a big issue, and this should be talked about during lifetime, of course. So some of these things are common sense, but we're going to drive that home today. If we can get families and couples and single people to think about this during their lifetimes, now we can build a support team, and we're going to talk about that. And people will say, well, what do I do at that time? And you know, what is the time period that I have to do something? Well, generally speaking, unless there's rental property, unless there is an urgent situation happening at the time of death, there's usually no real rush. And that's why I'm going to say most of the time, not all the time, but most of the time we can take our time and be driven by process and not by circumstances. How many of you on this webinar this morning have experienced a situation where you've seen a surviving spouse really struggling with grief, struggling with the pain of loss, struggling with what to do next, but yet they're driving themselves forward within the first week after they lose their loved one, or even sooner, or maybe within the first 2 or 3 weeks or even month, but they're really not emotionally ready to come in and deal with things, but they're having to. So that could be because they want to do their own estate planning, or they just feel the urge or the need to force themselves forward. So this is what we're talking about, that if we can have a team of support in place, if we can be driven by process, we can help people experience less suffering. We can avoid as much suffering as possible. And of course, we want to prepare through planning, education, and organization. And of course, that's what we're all about this morning. Now, we have a lot more to talk about the ups and downs of administration and what to be focused on and what not to be. But I'm going to give you some case examples. And Jeff and I have been doing this webinar on estate administration now for many years, and we do it once a quarter. And one of the things that attendees say the most, that they want the most, is they want to be involved in the examples. They want to understand the various case examples. So I'm going to give you a few this morning. We're going to talk about 4. We're going to get right into the heart of the material. I'm going to encourage you to get something to write with if you really want to make notes, or to get your laptop out and to really make some notes here. We're going to talk about certain kinds of examples. An example where the plan is absolutely clear. There's a clear structure. There's a clear path forward. Or there's a situation where there's lots of retirement type assets and maybe not so many trust assets, not so many estate assets, maybe a lot of beneficiary designated assets like TOD or something like that. Or there's a specific need. There is an administration going on, but the survivor's situation, whether it's a spouse or children or others, their situation has changed. It's different than the situation that was anticipated. And then maybe there's more what I might call fact-specific plans. There's really no plan or a poor plan, and we have to make some judgment calls. Maybe the situation is about as clear as mud. It just doesn't make any sense, and we don't know what to do, and we have to make judgment calls. So without further ado, let's get right into the examples. I'm going to use this first example. This is a single person. This is a single person. His name is Forrest. He died at age 82. He was never married, and he had one child, Edward. So far, this looks like it's very straightforward. And if we look down at the bottom of the page there, we see that Forrest had a will, and this will left everything outright to Edward. So this so far looks like a pretty straightforward situation. We have a single person that died with one child, so we know there's no other children we're aware of. There's no possibility for a dispute among the children. This is a will, and what do we know about a will? A will is, by its very nature, subject to probate. And do we have probate assets? So let's ask ourselves that question. What is probate, or what are probate assets, I should say? And the answer is probate assets are assets that are in the person's sole name with no beneficiary, and they are not jointly titled. So in other words, they're not joint and they have no beneficiary. So let's look at Forrest's assets. So when Forrest passed away, he had a residence. He was 82 years old, and there's no indication that there's a mortgage. He had $250,000 in cash. He had IRAs of $400,000. So there's a retirement asset. And he also had savings bonds. He had U.S. savings bonds. So when the son went to the safe deposit box, he found all of these savings bonds. Now, Forrest never made any gifts during his life, so he never made lifetime gifts. Now remember, Forrest could have made gifts of $15,000 per person per year with no ramifications, and if he had made gifts above $15,000, he would have used some of his gift and estate tax exemption. And what is that today? So we're throwing out a lot of things here so far. What is the estate tax exemption? Well, in 2022, it's $12,060,000 roughly per person. And we know Forrest was single, so he died with a federal estate tax exemption of $12,060,000. And he never used that exemption during life because he never gave away significant gifts. All right, so we know that about him. Now, he died in Maryland, let's say, and how much is the Maryland estate tax exemption? $5 million. So we have a $12 million federal exemption, a 5 million Maryland exemption. So we know if we look at his gross estate, if we add everything up, we know this gross estate is about $1.5 million. So is Forrest going to be subject to federal estate tax? No, because he's got less than 12 million. Is he subject to Maryland estate tax? No, because he has less than 5 million. And when he leaves all of his assets to Edward, is Edward subject to Maryland inheritance tax? Remember, inheritance tax in Maryland is 10%. Well, here the answer is no, because Edward is a lineal descendant. So Maryland inheritance tax does not apply to lineal descendants. So far, that's what we have. So what do we have here? Edward would, let's assume that Edward was the personal representative in the will. Edward would go to the Register of Wills and he would petition for probate. And I want you to look at your checklist. And we notice here at the top that the personal representative gets appointed and that the estate has an estate number. And the first thing we're concerned about is getting Edward appointed. So he gets appointed. He gets the letters of administration, which are the official letters with a raised seal that give him the authority to take control. And what's the first thing that he does? He says, what are the date of death values? And he starts to put together, or what we call in law, marshal all the assets. And he starts with that date of death value. And we know that he has to go through a process. He has to identify, is anything subject to inheritance tax with the Register of Wills? He has to get the house appraised, usually. Now, there are some times when that does not have to happen, but let's just pretend he's doing the highest and best thing. He's getting an appraisal of the house. Now, he's an only child. So a lot of this is simplified because he doesn't really have to account to anyone other than himself and the Register of Wills. But he starts that process, and what's going to happen is he's going to tell the Register of Wills in about 90 days. And you'll see this, that there is an inventory and an information report due within 90 days. Now, what does that mean? That means that he can open the estate with just general values. He can just say to the Register of Wills, this is a regular estate, it's more than $50,000, and I'm going to open this estate, and 3 months from now, Register of Wills, I will tell you how much these assets are worth. And that's called the inventory. Now, at the same time, he's going to submit something called the information report. And the information report is what the Register of Wills uses to identify whether any inheritance tax is due. So the inventory and information report are submitted within 90 days. The information report has 4 questions. And basically, those questions are a little bit counterintuitive when we read them. But the long and short of it is that they are asking, is anyone subject to inheritance tax? And were gifts made during life that would be subject to inheritance tax? And the answer is no on all of those questions. So as we go through this simple example, what issues do we see? Well, we know Edward's getting the estate process started, and he's going to follow that process. He can be represented by a CPA or a lawyer. He can do it himself. So sometimes people need this representation. Sometimes they choose not to have it. The registers of wills are generally very helpful, but CPAs and attorneys are available to help represent the personal representative and help them fulfill their responsibilities. And what is the major responsibility of a personal representative? Well, it's not just to do all of these things, but it is to account. It's to really account for everything and have that accounting approved, which we'll get to in just a moment. So here we have no problem with the residence. That's going to Edward. We have no problem with the checking, savings, and cash, taking control of those things. Edward is probably going to sell the house. We don't know, but probably he will. The IRAs, what does he have to do to claim the IRAs? Well, he has to make a death claim, and that death claim is due, meaning the whole process of claiming that inherited IRA has to be done and has to be pretty much started way in advance of the fall of the year following Forrest's death. So let's say Forrest died in February of 2022. The fall of the following year, the fall of 2023, is when these IRAs have to be finalized and they have to be moved over into an inherited IRA for Edward. So that's a long time, and Edward's probably not going to wait that long, but that's the timeline. There's a certain timeline for IRAs, and you as the personal representative would need to know that, or as a trustee. All right, so Edward will roll over those, not roll over, but he'll set up, inherited IRAs for himself. And how long will he have under the current law to actually take all of that money out of the IRAs? Well, under the Secure Act, because we have no indication that Edward is disabled or that he's chronically ill, and he's certainly not a minor child, he will have 10 years to take those funds out. So he's not able to stretch them out for his lifetime. He will only have 10 years before all the taxes due. Savings bonds, this should be a red flag to you to say, okay, we've got an issue here. All of the savings bonds, a pretty sizable amount, are coming to Edward, okay? And the question is, who's going to pay the tax? Because savings bonds are similar to IRAs. They're going to be called what we call IRD, income in respect to a decedent. So we know that income tax is due on these, and so this is going to be an analysis by the attorney, the CPA, or whoever is involved, that they're going to analyze where should this taxation be best allocated. Should it be allocated on Forrest's final tax return? Because remember, he has a final 1040. Or should it be allocated to Forrest's estate? Because remember, as you look on your checklist, you'll see that a Form 1041 is needed. What is a Form 1041? Well, it's what we call a fiduciary tax return, or really a better way of saying it is an income tax return for the estate. So Uncle Sam wants to know, from the time of Forrest's death until the time of distribution, what was the income of the estate? So the estate has its own tax ID number, and a 1041 would have to be filed. Now back to the savings bonds. Do we allocate some of the taxation to the estate, meaning the 1041, or Forrest, or to Edward? Edward is receiving these bonds. He's the beneficiary. So allocation analysis would be made to see where that should be attributed. So those are the kind of things I want you to think through in this fact pattern. Now, when we get to the bottom of our checklist here for estates, we see that the first administration, I shouldn't say bottom, forgive me, about in the middle of the page, it says the first administration account is due in 9 months. So looking at this fact pattern, there really shouldn't be any reason why Edward would not be able to close this estate within 9 months. All things being equal, this should be straightforward. So he submits his final accounting to the Register of Wills. The Register of Wills looks at it. The Orphans Court, I should say, looks at it. That's the court that's part of the Register of Wills. And that court is going to approve the accounting, or if they don't like something that Edward has said, they're going to ask him questions, and he's going to correct certain things that he may not have done correctly. And then they're going to approve the accounting, and then they're going to say, is there any exceptions? In other words, are there any objections? And there's a 20-day period. And of course, here, no one's going to object because Edward is the only beneficiary, most likely. There's no objections. And then everything becomes final, and Edward can administer the probate estate. He can distribute everything to himself. Jeff, I'm going to stop. We've been going for about 15 or 20 minutes. I'm going to see if there's any questions so far.
Thanks, Steve. We do have one question, and that question is the treatment of thrift savings for government employees the same as an IRA?
Thank you. To my knowledge, when the thrift savings plan is going to be distributed to a beneficiary, for example, a non-spouse beneficiary, it's going to be an inherited IRA that comes to the survivors, and that is the same as if it were a 401k And that's my understanding, and that's what we've always done. I think that's a great question.
Okay, that is everything for now. Thank you.
Thanks, Jeff. Now I'm going to move a little quicker because I want to make sure we finish on time, and I want to make sure that you have time for questions. Now, this second fact pattern, this has to do with a revocable trust. So remember, a revocable trust is an alternative to a will. So we talked about probate in the example of Forrest, the single person. Now here is a married couple. This is a married person, Philip, who unfortunately died at age 69, but he left a surviving spouse, Jacqueline, who is 1 year older than him, and 3 children. And here we have no indication that Jacqueline is ill. We have no indication that any of the children are not healthy. So let's just assume children and potentially any grandchildren, that there are no health issues. Now here we have more substantial assets. There was a joint residence. Let's just assume this was joint. The cash of about $240,000 was joint. There are IRAs and 401ks between this couple. And look at the brokerage account they have, which is been doing very well, and it's at 1.1 million. And there are smaller life insurance policies here, not tiny policies, but we have some smaller life insurance that this couple kept. Let's say they could have gotten rid of that, but they didn't. And look at this, they have a second home in Florida. They've made no lifetime gifts, and let's pretend they live in Maryland, they have a second home in Florida. They've made no lifetime gifts, and they have no creditors. And their gross estate, if we add everything together, and remember Uncle Sam includes everything, including life insurance that's owned by the couple. If we look at their total estate, it's $4,135,000. So the first thing we ask ourselves is this estate taxable? And the answer is no. It's under $12,060,000 for federal. It's under $5 million for Maryland, so there's no Maryland estate tax. And look at these children. There's no indication of anything except these are lineal descendants. So there are no, there's no inheritance tax. All right. So now we're administering a trust, and I want you to look at your checklist. And we're going to see as we get through the next slides after these fact patterns, we're going to see that trust administration is similar, but it does not have the exact same steps. But I want you to think in terms of, what did we talk about in the first several slides? We talked about what happens upon the death of a person, and we have a transitionary period. We have an administrative period, and that's what I want you to think about. Now here, if we look at the bottom of this slide, we see that this revocable trust of Philip left everything to Jacqueline in a marital trust. Now, why would Philip have done that? Well, if he was counseled properly, he would have 2 reasons for having done that generally. He would have provided asset protection for his surviving spouse, Jacqueline, and he would also have provided marital protection for the family, meaning that at Jacqueline's eventual death, this will go to the 3 children, generally speaking, and it will not go to a surviving new spouse. So those might have been the reasons why Philip created this marital trust, but everything is going to be administered at Philip's passing. Now remember, we have no probate here. And how do we know there's no probate? Well, let's just assume that the residence, all of the non-retirement assets like cash, the brokerage account, the Florida residence, let's presume, just for purposes of our webinar today, that all of those things were inside of the trust the way they were supposed to be. So there's no probate. And the 401k and IRAs, those are beneficiary designated properly, and the life insurance is beneficiary designated properly. Can life insurance go through probate? Yes. Can an IRA go through probate? Yes, if we don't have the proper beneficiary designations, and that would be a disaster, especially with regard to IRAs. All right, now the Florida residence will not go through probate because it was a second home, and it's also in the revocable trust. All right, so we have the job here is really to account for and move these joint assets into whatever percentage of Philip's ownership into the marital trust. So let's just presume that Philip owned 50% of the assets, let's just make a broad assumption, then his assets are going to go into the marital trust. So Jacqueline will have a marital trust, which is irrevocable and has its own tax ID number. And she'll also have her own continuing revocable trust. So Jacqueline will have her own assets that continue in her own revocable trust. She'll also have a marital trust for her protection, and she will be the beneficiary of that marital trust. Now, there's much more to talk about those subjects, but we don't have time today. I'm now going to switch to the second illustration at the bottom. It says, what happens if there's a formula clause? Now, what in the world does that mean? Well, let's pretend that Philip and Jacqueline had done their estate planning years ago, maybe in the late 90s, maybe in the mid 2000s, between 2001 and 2010, maybe even recently, but not probably that. Probably it was an older estate plan, and it might have what we would call a formula clause. And the formula clause basically says, at the death of one spouse, there will either be a marital trust, meaning a trust in the marital share, or there will be a trust in the non-marital share. And some of you may have heard of this, called the residuary trust, the family trust, the bypass trust, the credit shelter trust. All of those things mean the same thing, basically. That's what I mean by a formula clause, something that was automatic. Or the third example here, everything could go outright to Jacqueline with no further trust at all, and Jacqueline can just carry on with her life with her own revocable trust. So you have to look at the documents, and you have to see what the documents are dictating for the estate or trust. And here it's a trust. We also have to look at how the assets are titled. So let's say that the assets were titled where everything just went jointly to Jacqueline, but the document says that everything goes in a further trust. Well, then what's going to control? What's going to control is the titling. So back to lifetime now, when Philip was still living, hopefully what he did is he hopefully planned, and then hopefully he maintained his plan so that everything was titled, everything works the way it's supposed to. So here we have a pretty simple administration. Let's assume this couple did all the maintenance and updating. They made sure that all their assets were properly aligned with their plan. Now everything should go over to Jacqueline, either in the marital trust or in the formula or either outright. And the trustee of this trust, which usually would be Jacqueline, her job, with perhaps counsel and advice, her job is to move over these assets, and we don't have any estate tax to worry about. She needs to roll over the 401k and IRA to her name. Now remember, she is the only person who can do that because she's a surviving spouse. So why does she have these options? Well, she actually has two options. She can roll the IRA money to herself in her own IRA, or she can have an inherited IRA. Most of the time, she's just going to roll that over to her own IRA. She won't choose an inherited IRA, but she could. So what are the big issues here? Well, I don't see a lot of big issues. The Florida residence is going to be properly retitled either in one of these trusts for her because of Philip's death, or it's going to be retitled in her continuing revocable trust. But as we get away from the retitling issues, which are pretty straightforward, the other issue I want to advise you about here is really just look at this process from the beginning. There may be a good reason to get date of death valuations here, but sometimes these are ignored on the death of one spouse. But what is the major tax election that I would want this couple to look at? And I would want you to think about this if you were in this situation. We would want Jacqueline to choose portability, or to at least consider portability. And what is portability? Well, to make a long story short, if you don't already know this, portability is a simplified way to do estate tax planning. Jacqueline, because she survived, she can choose to utilize, or however we want to say it, choose to port Philip's $12 million federal exemption and Philip's $5 million estate tax exemption, she can choose to utilize that exemption and to save it for herself. So in other words, she can choose it, and she does that on Form 706. And on these checklists, you're going to see that the survivor can make the portability election. And how long do they have to do that? Well, they have 24 months. So there has to be a tax election made within 24 months for that. Now, will Jacqueline wait 24 months? Hopefully not. She's going to need to make a Q-tip election. Now, what in the world is that? Well, that is the marital trust election that you see. If she had a marital trust, that election has to be made within 15 months. So that's all done on the same form, which is Federal Form 706, and on the Maryland estate tax return. So what we want to do here is recognize that there are tax elections that have to be made. We're not going to wait 15 months or 24 months. We probably want to do this within 8 or 9 months at the latest and make these elections. Now, does Jacqueline have to make these elections? Well, she does have to make the marital trust election because that's what Philip's trust said should be done. But she does not have to make the portability election, okay? So my point is that if she chooses portability, the federal government or the Treasury has come out with a regulation that says that the IRS can never take away that ported amount. So that's why I think it's very important for clients to know that that portability election is there. And most of the time, I'm going to advise them to make that portability election, even though it's going to cost money to prepare the Form 706. Now, if someone has a marital trust like this and the 706 has to be created anyway, then to me, this is kind of a no-brainer, so to speak, that they are going to do those two elections on the Form 706. So I don't really see any other issues here that are really coming out at me. Jacqueline looks like she's going to be well taken care of, and it's just going to be driven by process and getting this surviving spouse moving in the right direction after Philip's death. Now let's go to the next fact pattern, and we're going to do our best to get through this and finish up on the other slides. We have two more examples. Here we have the same couple, except we know Philip died, and now 15 years later, Jacqueline now passes away. And when she passed away, she has 3 children, the same 3, but look at what's happened. We now have a disabled child. So a situation has changed. It's an unexpected situation. And look at this fact pattern. Now we see that Jacqueline is living in a continuing care retirement community, and it's one of the nicer ones. She's made a large deposit. There's a deposit there at the community. She has cash now in the 400 range. She still has the IRAs, and those are in her own name. The brokerage account, because of this stock market that happened over the last 15 years, now her assets have gone way up. There's a $2.6 million brokerage account. The Florida residence, right? This real estate boom that we've been in, look at that. Maybe it would have gone even higher, but the Florida residence is still there, and it's $925,000. Now, she's made no gifts during life, but she does have a changed situation now. For some reason, there are creditors. I don't know whether Jacqueline was just being irresponsible for some reason. Maybe she was affected by illness. Maybe she's not paying her bills. Not specific to Jacqueline, but we've even seen circumstances where someone is gambling or has been victimized by fraud, and she has several creditors. So let's talk about that for just a second. Since 2014, creditors can make a claim against a revocable trust. In theory, creditors could always make a claim against a revocable trust and not just an estate, but I have never seen it, and I don't know anyone else that I know who has seen an actual claim. I could be wrong, but I don't know anyone who has seen a claim against a trust. But now, because she has creditors at her death, even though she does not have an estate, let's pretend all of these funds are in her trust. What do we do? Well, the Maryland Trust Act allows you as the surviving trustee to run notice to creditors for the trust, not just an estate. but for a trust. And that gives notice to creditors. And if they do not make a claim against the trust, then, and we don't expect that they would, but we know they could. And a best practice is to notify creditors so that you're protecting the trust. Now, many people will say, well, even though she has creditors, we're not going to do that. Or let's pretend Jacqueline did not have creditors. Even if she didn't have creditors, I would still argue that the best practice is to run notice to creditors, which the Maryland Trust Act allows you to do as a trustee. Now, there are other requirements of the Maryland Trust Act that beneficiaries have to receive notice. Remember in our first example, when Forrest died and there was probate, remember that the Register of Wills sends out notice. If you did not know that, notice to interested persons goes out. Here, notice to qualified beneficiaries has to be given by the trustee. So there are certain requirements since 2014 of the Maryland Trust Act. So we want to give notice to creditors, in my opinion, so we can foreclose the claims of creditors. If they don't make a claim, they're out of luck. We also want to notify qualified beneficiaries. Okay. Now let's look at the assets here. Do we see anything that's a problem? Let's look at the estate. The estate is $6,037,000. Okay. So what do we know here? Do we have a taxable estate? Well, we're under $12 million for federal, $12,060,000. So we don't have a federal estate tax problem, thank goodness, because that would be 40% tax, and we don't want that. But it looks like we do potentially have a Maryland estate tax problem because we're over 5 million. So what is the maximum Maryland rate? It's 16%. So potentially we have a problem here. So as we look through this, we've got a little bit of an issue here at first. We look at this, but now we step back and what do we say? Oh, but we forgot that Jacqueline chose portability at the time of Philip's death. So remember when Philip died 15 years earlier, in my example, Jacqueline chose portability. Well, here it really paid off because now with her 5 million and Philip's 5 million, she has 10 million of exemption for Maryland. So there's not going to be a Maryland estate tax. So she probably just saved about $95,000 or something along those lines in state estate tax. So that portability really paid off. Now, another thing I want you to see here, everything is going to the children equally in further trusts. And remember that when Jacqueline and Philip did their planning, they planned for healthy children, and they never really revisited that plan for some reason. After Philip's death, Jacqueline never revisited the plan. So here we have 3 equal trusts, and I'm just going to go out and say these were general trusts. They were for health, education, maintenance, and support. So the first thing we see here is we have a brain injured child. This person was driving to work. They were involved in a car accident. They have a brain injury, and now their therapy is $30,000 a month, or their health care costs are going to be through the roof for the rest of their lives. What do we do? Well, what you're going to want to do is look carefully at the documents, and we want to hope that those documents provide for a safety valve where this particular child's share can be funneled into a supplemental needs trust. So hopefully these documents have been updated and they have modern provisions about protecting the share of a person who's been injured and basically has become a special needs person. If there are no such provisions in the document, it may be necessary to decant that child's trust. It may be necessary to set that trust up, but then to have a decanting statute like those of maybe 20 to 25 states, Virginia, Delaware, South Dakota, Nevada, using one of those states to change this child's general trust into a special needs trust. So that's the first thing that catches my eye here is a state tax possibility, but no, we've chosen portability, so no estate tax. Then the issue with the disabled child, that should raise your eyebrows, and you can do something about that. And if you're a proactive trustee, you can do something. Are there trustees who are not proactive and they just go through the motions? I would argue, yes, there are. There are people out there that do that. I don't recommend that because you have a fiduciary responsibility, and we want to make sure we're doing the highest and best thing for the estate and for the beneficiaries. What else catches your eye here? Well, in the interest of time, I'll say what really catches my eye is this specific gift to a niece. So there was a niece, and after Philip's death, Jacqueline amended her revocable trust. She gave a $150,000 gift right off the top, a specific gift to her favorite niece, a very lucky young lady. And now what happens? Well, we have inheritance tax because the niece is going to be subject to Maryland inheritance tax, and that is 10%. And we look at the document, and the document is either going to say that the tax is apportioned to the niece, or many times the document is going to say there is no apportionment. And what that means is that the trust itself, meaning Jacqueline's revocable trust, will pay for the inheritance tax. So if you're the trustee, what do you do here? Well, you have to file an application to fix inheritance tax on non-probate assets. I'm going to repeat that. You have to file an application to fix inheritance tax with the Register of Wills on non-probate assets, because remember, the Register of Wills, what do? They collect inheritance tax. So that's what you're going to do, and then you're going to receive a bill and you're going to pay that inheritance tax. Now, what if Jacqueline had that $150,000 gift in there, but she had given the gift 3 years earlier? She gave the gift to the niece in advance. And let's pretend that the trust said, well, if I do this in advance, then this gift is null and void. So she gave this gift 3 years earlier. Is there inheritance tax? And the answer is no, because she gave the gift more than 24 months prior to her passing. All right, so looking at this fact pattern, you're going to administer this trust. You're going to distribute the assets after you've accounted for everything if you're the trustee. You're going to do a very careful accounting. You're going to date of death value everything, and then you're going to account for everything during that transitionary period. You're going to make sure or help the beneficiaries receive their IRAs. Now, what do we see here? The beneficiaries are receiving assets in further trusts. So you're going to help the beneficiaries as their IRAs are actually going to be retitled or actually owned. Those inherited IRAs are going to be owned by those further trusts, and each one of those trusts has to receive a tax ID number. So you're not only going to account for everything, make sure everything is sold properly or retitled properly or claimed properly, and doing all the final tax returns, including the 1041 for the trust, Jacqueline's final 1040, making sure all the beneficiaries have been able to get their inherited IRAs, their new trusts are set up for them. You're going to go through all of those motions, and then before I should say that you distribute the assets, what are you going to do? You're going to want to get a consent, waiver, and release form. You're going to want to be released from liability. You're going to want to be smart, and before you distribute the assets, you're going to want the beneficiaries to relieve you of liability, to review the accounting and accept it, and to relieve you from liability and the possibility of lawsuits. Remember that in the probate process, the court finally approves the accounting, and that gives you a lot of protection. But in a trust administration, you don't have that protection on an ongoing basis, on a routine basis. So you're going to want the beneficiaries to sign off before they receive the funds. Last fact pattern, and then we're going to move a little bit more quickly. We have someone whose name is Richard. This poor man died at age 63. He was separated and he had 2 children. Now, if we look at the bottom of this fact pattern, we see this is one of 2 things. He either died with no will, or he did die with a will, leaving the estate to the 2 children. So this is a fact pattern where there's no trust. It's just a will, or in another example of the same fact pattern, there would be no will. So he was separated from his spouse, and at the time of his death, his spouse Sylvia lived in another state, and she is not a U.S. citizen. So here is a separated married person with 2 children. His spouse lives in another state. She is not a US citizen, and one of the children is in bankruptcy. That just happens to be one of the unfortunate things. So let's just assume, in the interest of time, we won't go through both fact patterns perhaps. We're just going to go through an example where there is no will. Maybe that is the best way to end our examples today. So the checking is going to go through what? It's going to go through probate, but it's going to be distributed according to the laws of intestacy, because we're just going to pretend for this example that this gentleman had no will. Now, his inherited IRA, he already owns that. He already owns that, and let's pretend that he has no beneficiary. He received this from someone else, but he never beneficiary designated it to anyone. What's going to happen with that? That's going to go through probate. His automobile is in his sole name. That's going to go through probate. His life insurance, look at this big life insurance policy. He's only 63, so it looks like he bought a big term policy, and that term policy was still in effect, surprisingly. Most of the time, they're not in effect, but here we have $1 million. But look what's happening. That $1 million, unfortunately, had no beneficiary, so where does it go? It's coming into the estate. Are savings bonds part of the estate? Yes, we have the same issue. Who is going to pay the tax? Is it the children, or the beneficiaries of the probate estate, the intestate estate, or is it his estate, or is it his final tax return that picks up the taxation? He did make lifetime gifts. He made a gift during his lifetime when he had a lot of cash at one point, and he did use some of his lifetime exemption. But his lifetime exemption from gift tax is so large that this $500,000 gift does not make much of a difference. So he did make a gift, but it's not going to affect him because he could give away up to $12,060,000 during his lifetime. So his gross estate is $1.9 million. We don't have any estate tax issues. They're under $5 million for Maryland. We have no federal estate tax issues. It's under $12 million. We have no indication of inheritance tax because his intestate estate is going to go to what? Both his spouse and his children. And it's roughly 50-50. There are some allowances for Sylvia, the surviving spouse. And it doesn't matter that she's in Florida. And it doesn't matter that she's not a US citizen for this particular purpose. The intestacy laws are going to dictate that roughly 1/2 is going to go to the 2 children and 1/2 is going to go to Sylvia. This is rough estimate. And everything is going to go that way. Unfortunately, the inherited IRA is going to have all tax due because there is no beneficiary. It's into the estate. It's actually subject to the 5-year rule, but for all practical purposes, it will be taxed in 5 years. The life insurance will be part of the intestate estate. The savings bonds, tax will be due. We're not worried about the gift. So here, the only thing we would be concerned about a non-citizen spouse is whether or not we had a will or a trust. If we had a will or a trust, for her to qualify for the marital deduction, meaning the advantages of marriage in estate planning, we would have to use a qualified domestic trust, meaning she's not a citizen and the US government does not want her to receive money and then run off to her home country and avoid estate taxation. But here, we don't have to worry about that too much because there's no will, there's no trust. The laws of intestacy are going to control and distribute everything outright to her. And fortunately, we don't need the advantages of the unlimited marital deduction because we're under 5 million, we're under 12 million, and certainly we're under 24 million for both spouses. The surviving spouse, Sylvia, could choose what? Portability, but she probably won't because they're separated. She lives in Florida, and this is an intestate estate, but she certainly could choose portability. All right, so that is 4 fact patterns. I know I took a long time on that. Jeff, I'm going to stop very briefly, and then we're going to go through the other slides. And I hope those 4 examples really give you a feel for some of the issues we're looking at in relation to these checklists.
Thanks, Steve. No other questions now, so we can, actually, we have one that just came through. Let's see, it says, this presentation is very informative. However, is there a special needs trust series provided by your firm? So I can answer that. So absolutely, we do have several special needs planning presentations that we do offer, and I can send out some information about that in my follow-up email after the presentation. So thank you for your interest.
Yes, thank you for that question. And I'll just go as far as to say, in any of these fact patterns, except for the last one, and then we'll cover something that's important on that last slide. I'm going to go back to it actually. In any of these fact patterns, there could be a special needs trust that's needed. And in one of these patterns, well, let's just take this one. Let's take this last fact pattern where there is no will and one of the children is in bankruptcy. Well, we didn't cover that a lot on that, so let me speak to that very quickly. There's really nothing we can do here. That share is going to go to that child, and unfortunately, it may be lost in bankruptcy. So there's no protection, and that's one of the downsides of this not having a will here that would provide for a further trust for that child. But now back to special needs. Let's pretend that there was a will here, and let's pretend that one of the children had special needs. Well, what we would want to do is look very carefully at that will and see if there was any outlet, if there was any kind of a safety valve built into that will, if there's anything we can latch onto and say, this gives us the authority to establish a special needs trust for that child and not distribute the money to them outright. Now, if there is no such mechanism, or if we're stuck with this intestacy fact pattern right here, then there's nothing we can do but distribute the assets to the special needs child. But because that child is under 65 years old in this fact pattern, most likely, we have the ability to use a different kind of special needs trust to protect that child's share. So promise that Jeff will forward that information. Okay, thank you for setting through what I was really emphasizing in those new fact patterns is really digging into the process, really digging into the red flags that you should be looking at. And now I'm going to go through more process. So we want to have empathy for clients and the fiduciary situation. We want to see what kind of family support they have and what they need. So people are suffering at this time, and hopefully they do have a team, and meaning the professional team, and hopefully they have the support at home that they need. If you're a professional, we always say the whole firm should be involved. Everyone should know about this, and if there's any help or support or resources that we can provide, and that gets to the next issue, we want to be creative with resources, and we want to have the ability to direct or be a resource, and those things are just so important today. Many people are isolated due to COVID and the state of the world, so we want to be able to reach out to them and provide resources. Now, we want people to take care of themselves first. We know this is a non-scientific thing. We want them to know that there's no hurry in most circumstances. We want to advise all the team, the advisors, the CPAs, the attorneys, the life care managers, everybody that's involved, an insurance professional. We want to make sure that everybody's notified. We want to assure the client or the fiduciary that everything is in order and that funds are available. And that needs to be talked about during lifetime, making sure funds are available. We want to assist with final arrangements and even attend the funeral. We want to send flowers and do all of those human things that are very, very important, not just the legal technical things. So what is the legal process as we go back to the checklist? Well, what we've hopefully shown in those examples and in the checklist is probate, and then there's non-probate. These are similar steps, but there are different checklists, and no matter what the situation is, organization is the key. What you've seen in those examples, and hopefully this will now formulate in your minds, we've got date of death issues and values, letters of administration in a probate estate here, inventory and information report. We've got valuation dates that are alternate valuation dates, claims against the estate. We talked about claims against the trust, claims against the estate have to happen within 6 months of when? The date of death, not the date the estate was open. We have to be aware that there is a new spousal election that's allowed, a new spousal elective share law. Is the surviving spouse getting the bare minimum that they are entitled to? Disclaimers. What if we are making a tax election or another election called a disclaimer that has nothing to do with taxes, or it does have to do with taxes? Those are due within 9 months if we want a qualified disclaimer. Disclaimers can be made in general anytime before the estate is closed, but for a qualified disclaimer within 9 months. Federal estate tax returns are due within 9 months. We talked about the dates of the portability election and other elections. And that leads us to the next slide. The Q-tip election is made within 15 months, 24 months for the portability election. And then in probate, we have accountings that are due. The first one is usually due in 9 months. And then maybe there are subsequent accountings that are due. So this is the probate process in a nutshell. And remember, the release of liability for the personal representative is really the court approving the final accounting. But a personal representative might seek other release from liability, but that's a different subject for another day. Retirement plans, I mentioned in the examples that retirement plans have a timeline that by the fall of the year following death, we better be stepping through those processes if we haven't already done so to get the retirement plan into the hands of the beneficiaries or into their trusts. The Secure Act has changed how we have to look at retirement plans. Most beneficiaries are only going to get 5 years to, 10 years is what I meant to say, 10 years to stretch out the IRA. But if you are one of, or the beneficiaries are one of these 5 categories, they are not subject to the 5 years. Minor children, surviving spouses, people that are less than 10 years younger than the plan participant, chronically ill people, and disabled people, meaning people with special needs. So those 5 categories are exempt, but we have to understand the 10-year rule is going to apply to most everyone else. There is the 1041 that's due and the Maryland 504 form. These are the income tax returns for the estate. And then, of course, we want the decedent, they to have their final 1041 filed. If there are estate tax issues in the estate, we want the closing letter from the Comptroller of Maryland or the IRS. And now if we switch in the interest of time to what happens with a non-probate estate, meaning we've got a trust and let's just pretend it's fully funded, all the assets are properly aligned, we have the same issues basically. And that's what I want you to take away from today. The revocable trust is technically distributable the moment of my death. If I have a trust, I die, the moment of my death, technically it can be distributed. And in some cases where we have a single child, a sole only child, that is very much what happens many times. Very little administration is done and then everything can be distributed. But when we have more than one child, what do we want? We want to walk through a process. We want to make sure that not everything, we want to make sure everything is accounted for. Now, of course, the only child also wants to account for everything. I'm just trying to say the process can be shorter. So in the interest of time, I'm not going to go through all these bullet points, but you're going to see that many of them are very similar. The Register of Wills is not involved here unless we are asking for them to assess inheritance tax. Notice to creditors is optional, but in my mind, it is a best practice. My point of all of these slides is to say that the process of administration for probate versus non-probate is similar. And in the non-probate administration, we want to follow many of the same steps, although we are not obliged to jump through some of the same hoops as the Register of Wills. We talked about release, waiver, and refunding agreements, or the release of liability, so we've covered that. We've covered the fiduciary tax returns. We've covered the closing letter. You see, if you look at this, you see it is similar. It is not the same, but it is similar as probate. So what are the practical steps? Well, we want to schedule meetings with surviving spouses within about 30 days. Yes, there are times when it needs to be faster. There might be rental real estate. We might have frozen pipes. We might have things that have to be done. A lot of this hopefully is addressed prior to someone's passing, but if not, we need to speed things up. But generally, we want to follow a process. We want to coordinate with other advisors, CPAs, attorneys, life care managers, all of the people that are involved. We again want to use the checklist. I'm being intentionally redundant, and we want to be organized. We want to have an inclusive process. We don't want a process that I've seen many times when I was a much younger lawyer, where this person who's a professional is really not talking to this person, and there's really no coordination. So we want to do reasonable due diligence, make sure that people are coping with grief. We, again, want to be methodical but not hurried if we can avoid it. And we want to encourage surviving spouses to do their own planning, but not when it's too soon, not at the risk of pain and suffering when the time is right. So we want to be sensitive. We want to be compassionate. We want to understand that this is one of the worst times of someone's life. And we also want to be on top of the process, but to be compassionate in our approach. Now, what are other practical steps? Well, again, organization and general readiness. How do we do that? I think we do that by looking at planning as a three-step process, or however many processes you want to number it, but basically three main processes. Putting our planning in place, maintaining the planning, step number 2, and then final administration. So storage of documents, organization, maintenance and updating, making sure everything is titled properly, making sure that digital assets are archived properly, that things are readily available, making sure that cash is available. During the COVID period, I will just say, disappointingly, I feel that some of the big brokerage firms are not doing very well. Their customer service has been lacking. Their organizational readiness has been somewhat lacking. And I think many estates and trusts, or especially trusts, have suffered during COVID, where they're taking longer than they should. But generally speaking, if we organize during life after planning, we have maintenance and updating, we are going to be much more ready for administration, and we want to be ready. That should be part of the planning. A very good advisor once said to me, Steve, it's one thing to educate, which Elville and Associates does. It's another thing to also be organized. And we also want to focus on organization and not just education and other readiness. All right, so what do we want to do? We want to review the titling of assets prior to death, as I just mentioned, with a collaborative effort. We want to make sure we value all assets after death. We want to be cautious in the retitling. To the advisors and surviving spouses on the call here this morning, we see a trend where financial advisors are retitling assets way in advance. They are, or I should say, way too soon. So after the death, in a spousal situation especially, we don't want assets retitled in the name of the surviving spouse until we are able to look at the process. And what is the process? What do the documents say? Should the assets be retitled in the name of the surviving spouse or in the marital trust? Or life insurance was claimed too soon. A large life insurance policy was not supposed to be claimed by the surviving spouse until we decided whether or not we have any estate tax issues. So we don't want to be too quick to retitle assets, and this is a trend that I'm seeing. Inheritance tax, again, we have to look at that. Do we have an inheritance tax issue from the get-go? Do we have a portability election issue? We want to make sure that's calendar. Do we need to make a Q-tip election? Is there a claim of a creditor that could occur? And are we foreclosing those claims of creditors? The entire advisory team wants to be talking, not just one of them. We want to be talking and coordinating. And this is not as easy to do as it may seem. We want someone to be the quarterback of this coordinated team, and that needs to be decided. So having a team is important. If you don't have one, I encourage you to get one, and we can help you get one. But also coordinating with that team, or coordination within that team, that's incredibly important. We want to invest significant time during lifetime. I know I said this 3 or 4 times, I apologize, but it's being driven home to you today. We want significant time spent during lifetime to ensure that all assets are aligned, All documents are updated. If illness is obvious, my experience is that death can occur much quicker than we realize in the general sense. We want to expedite meetings where we see signs of illness or a concern about illness. We want to ascertain the wishes of the client and encourage memorandums. Memorandums are what separates one set of documents from another. It personalizes it for the client, and it helps the trustee to know how to administer the assets, or the personal representative, how to administer the assets and how to continue to administer the assets if there are further trusts. For example, a special needs trust, like one of the listeners said. So again, we want to encourage organizational tools, organize and also educate family members. We want to have ongoing education. Those of you on this webinar this morning, I congratulate you for your willingness to continue to educate yourself. We want systematizing, we want lists, we want to disseminate information quickly, and we want to instill confidence in the client or the surviving spouse. Now, I went through those last slides very quickly, and I apologize. They're there as a tool for you. Some of those are redundant points I'm driving home, and I hope that it was okay with you today that we spent a lot of time on those examples, and I used the checklists. I used our time to try to show you the high points, the red flags, the things that should, really open or raise an eyebrow as you look at the various fact patterns that you're going to be dealing with. And we want to educate, we want to point out these high and best practices, but we also want to give you a path forward. So if you are dealing with an estate, we would be happy to consult with you. If you have a collaborative team, if you have a CPA or an advisor, we would be glad to be part of that team. Or if you don't, we would like to help you get that team in place. If you don't have a tax preparer, we want to help you get a tax preparer. You can complete a questionnaire, and we want you to know that there's nothing to fear. You can bring your situation here to have it evaluated, and we will help you to kind of get on the right path. We can use our state-of-the-art equipment here, and we can show you what the process looks like on the whiteboard. We can give you step by steps to accomplish what you need to accomplish. And if you need representation, we can actually help represent you in your capacity as a fiduciary. If you are just on this webinar today because you want to know what is going to happen in the future and how do I face these administration issues, then I encourage you to have your current documents updated and to have them reviewed. And that's the first step, because remember, you've either created documents or you're going to create documents. And then we want you to have a mindset of collaboration with us and partnership with a law firm like us, that we can help maintain and update your planning and educate you and your family members throughout lifetime, not just having a set of documents, but having a process during lifetime, which will inevitably, with your participation and your diligence, it will lead to an administration that can be as smooth as possible, which is what a lot of people have as a goal. Other people have a goal that says, I want to minimize cost. So whatever your goal may be, remember, all planning is goal driven. All planning for death is goal driven. Planning for the administration process is goal driven. All estate planning from the beginning is goal driven. And all maintenance and updating is intentional. So we want to encourage you to do that, help you have an advisory team, bring your questions, bring your issues. We will help you work through them. And we're going to do this once a quarter. We're going to give you time to think during these sessions and hopefully in our conference rooms, and use this as a tool, use us as a resource. Jeff, I'm going to turn it over to you, and I just want to thank everyone for their patience. That was a lot of information. We can't cover everything about administration in an hour and a half, but we sure did try, and I hope that this has been valuable to you. You can walk away with some substance that you can practically use. Thank you, everyone. I'm going to turn it over to Jeff.
Thanks, Steve. Appreciate your time. Great presentation as always. Got a lot of comments that's very informative and helpful to their situation. So thank you.
Thank you.
So now be your time to get those final questions in as at 11:25, and we want to end on time. And Steve, we do have one question for the time being, and that question is, for non-probate, there was a line in the slide that stated spousal election not yet in Maryland. Can you explain what that means?
Thank you, and I appreciate you bringing that up. That's something that we need to clean up on our slide. Thank you for bringing that up. There is an election now that was pending in October of 2020, and that is called the new spousal elective share law, but it actually became law, I should say, as of October 2020. So the new spousal elective share law allows a surviving spouse, and this is not the normal situation, but let's pretend the surviving spouse was disinherited, or the surviving spouse did not receive at least 1/3, or in some circumstances, 1/2 of the estate. What the new law allows is a surviving spouse has protections that he or she never had. And the best way of thinking about it, in my view, is that 30, 35 years ago, surviving spouses really had very little protection. And now the pendulum has swung this way, that the surviving spouse has massive protections, and they are entitled to certain amounts of the entire estate. 35 years ago, the estate was considered just to be the probate estate, but now the augmented estate or broader estate is not only what goes through probate, but the revocable trust, retirement plan assets, and other trust assets that are left for a spouse. So the surviving spouse has the right of election, and this is all designed to make sure that the surviving spouse at least gets a certain amount of assets, whereas in the past, surviving spouses did not have those kinds of protections. And it's beyond today's discussion, but because of some wonderful collaboration between legislators and elder law attorneys and the estates and trust attorneys in the state and the section councils of the Maryland Bar Association, there has been a wonderful compromise where in special needs planning, the augmented estate between spouses and the special needs planning that can be done between spouses has been greatly enhanced. So that has to do with the rights of a surviving spouse, and it also has a little bit to do with protecting a surviving spouse who is disabled, and a special needs trust is being left for that surviving spouse.
Thank you, Steve. And apologize for missing that. We looked through these presentations many, many times, but sometimes miss something like that. So we will have it changed for next time. So next question is, I believe you guys have reviewed some items in this seminar. However, is there a suggested checklist to review with family aging parents to help everyone involved getting all ducks in a row for future passing?
That is a great question. I think that there's been a lot of ongoing efforts by some financial advisory firms and attorneys to create a checklist at death. These are the things that should be done, not just these legal technical things with trusts and wills, but also like a practical list. This is what should happen. And we have access to those kinds of lists. What I think you're asking about is there a checklist that could be reviewed that has to do now during lifetime? You know, am I doing this? Am I doing this? Are there things we're not thinking about that could happen? Do we have enough flexibility in our estate plan to deal with changing circumstances, and not just a checklist of this is what happens at death? I thank you so much for that suggestion, and I think that we don't have something I could lay my hands on today to say, yes, we have that list, but I think that Jeff and I have the resources to be able to compile such a list or start one. And if you could send your contact information, we will get that to you as soon as we do, because that's an excellent question. We have processes here at Elville, and those are educational processes, but that kind of checklist would be an excellent idea for us to implement. And so we'll be in further touch about that.
Yeah, and we do have a lot of resources here at the firm and outside. I think that we could certainly put our hands on something. I have a couple of ideas. Steve and I will discuss at our meeting tomorrow morning, which we have every Thursday morning. Next question. Actually, a comment. Thank you, Steve. This has been very helpful. I appreciate that Elville provides an ongoing seminar series for your clients and are a valuable resource. I appreciate you, Jeff, and your team. So that's very nice. Thank you so much.
Thank you.
Really appreciate it. Next question, does direct lineage include parents, not just children?
Yes, that's great. I thank you. I think you're referring to inheritance tax. And if that's what you're referring to, the answer is you're right. If we left assets to parents, they are not subject to inheritance tax.
Okay, great. So it looks like those are all the questions for now. If something pops up in your head afterwards and you'd like to send it our way, we'll try to get an answer to you just as soon as possible. So we are at 11:30. Just real briefly, I'll send out the video for today, a couple of further resources for you as well. Another thought, I'm grateful for the cooperative and future planning approach of Elville and Associates. Well, thank you very much. We do appreciate that very much. Try to be collaborative, compassionate, provide a lot of education here at the firm. I think that's just the right thing to do and the way we do things at Elville and Associates. So also just briefly, and then we're going to stop, our webinar series, Tuesday the 15th, we have our wellness series, Purpose and Health, the important link. So that's with Ellen Platt and Dr. Michelle Fritsch. That's part 5 of our wellness series. Friday the 18th, we have estate planning elder law essentials with Steve. And then really excited, we're starting a new partnership with Mr. Andre Lingham. He's a former Howard County Police Officer of the Year 2 times and founder of the Center of Elder Justice and Education, starting a mini series on financial exploitation, frauds and scams targeting seniors on Tuesday the 8th, and then on the 22nd of March, identity theft, the illusion of privacy. So we are really excited to be partnering with a gentleman such as Mr. Lamb, who is so well known throughout Howard County and beyond on those 2 new topics. So invitations for the 8th have already gone out, and we'll have something for the 22nd soon. It's already on our website if you want to look at more about that and those presentations. So I think that's everything for today. Thank you for being a great audience, and we appreciate your support of our webinar series and interest in Elville and Associates. Please fill out our survey. Let us know how we did today and any thoughts you may have further. And we look forward to seeing you again very soon. Have a great day.
Thank you, everyone.